Okay. Hello, everyone. Many thanks for joining us for this exciting webinar. We at Sultan Al-Abdulla and Partners are thrilled to be part of the Paris Arbitration Week and are excited for the series of webinars we have planned as part of our collaboration with Paris Arbitration Week. My name is Umang Singh, and I'm a senior associate at SAP. I will be the moderator in this session. Before I kickstart the discussion, I'll just take like a couple of minutes to introduce our panelists. And also I would like to extend a big thanks to them. I know how busy they are and they have taken their time out to be on this panel. Thank you, Ned, Alex, and Rohit. So Ned Beale is a partner at Horsfeld. He's based out of London. Ned is a leading commercial disputes lawyer who specializes in complex commercial litigation as well as arbitration. He has experience of sitting both as an arbitrator and appearing as a counsel in big commercial arbitration, and is also a fellow of Chartered Institute of Arbitrators. Alexander Wyatt is a legal director in the litigation and dispute management practice at Eversheds in Doha. He's also part of the Eversheds Middle East construction team. Alex specializes in dispute resolution with a particular focus on the ICC, LCIA, and KICA arbitration. KICA is a local Qatari institution which administers arbitrations in Qatar. He regularly leads local and international arbitral proceedings, as well as mediation, dispute adjudication boards, and expert determinations. And finally, Rohit Singhal. Rohit is CEO and founder of Mason Projects. Mason provides expert engineering and construction claim analysis services, as well as expert testimony services to the engineering and construction sector worldwide. They have extensive presence in India and in Middle East. Rohit is a techno-legal entrepreneur and has more than 25 years of consulting and management experience. He has appeared as an independent expert in more than 50 international arbitrations and is very well known as a delay and a quantum expert worldwide. Now, moving on to our topic today. Our topic today is mediation and international arbitration. So I will now invite Ned to briefly explain to our audience what is mediation and how it helps the dispute resolution process. Hi, Ned.
Thanks very much. And thanks everybody for joining. It's great to be speaking about this because I think it's a really interesting subject. And I'd just like to give my perspective as a UK-based international disputes lawyer. So I do probably 50% international commercial arbitration and 50% high court work in London, involving international parties. And I mediate very regularly, so a couple of times a year at least. However, thus far, in 20 years of practice, 100% of my mediations have been in high court proceedings, and 0% have been in international arbitration. And I have found mediation a really effective way of resolving disputes. And I think it's a great pity that my personal experience is mediation is underused in international arbitration. So just by way of introduction, to explain what I mean by mediation from a UK perspective, for me, mediation is usually a one-day process, potentially two for a bigger case. The longest I've had was 5 days, which was Brazilian and Italian parties. And that quite frankly went on too long, albeit it's settled. Before an independent mediator, who is usually a senior lawyer who practices now solely as a mediator. So there's a pool of about 30 or 40 leading UK mediators who really everybody wants to instruct. Probably takes 3 months from start to finish. But most mediations are similar. You prepare your position papers, you get together, you spend the first part of the day in a plenary session with each side explaining why their case is correct and the other side is wrong. And then sooner or later, about 2 p.m, the mediator says, well, this is all very interesting, but are we going to get a deal or not? And everybody starts talking numbers. And sometimes that ends at 4 p.m. and everybody goes home. And sometimes that goes to 2 a.m. and you get a deal. And I have really found it a very effective way of knocking parties' heads together and getting a resolution. And in high court proceedings, mediation is basically mandatory. The courts don't say it's mandatory, but it is part of the standard directions in the commercial court, in the Chancery Division. Every judge would expect you to mediate, and you can be penalised on costs if you don't mediate. And that is a Court of Appeal decision, Halsey and Milton Keynes General Trust, which is now almost 20 years old. Lord Justice Dyson, as he then was, said that a winning party was not entitled to its costs because it had refused to mediate shortly before trial. And that really scared everybody. And my advice, and I think every lawyer's advice to clients is, look, you cannot just refuse to mediate. It's too risky because you might win, but you might get none of your costs back. And indeed, Halsey was applied last year in Wales and CBRE managed services. So that's my experience in high court proceedings. And by the way, these are largely international. So the last couple of mediations I've done involve parties from Bahrain, Dubai, Pakistan, and Russia. So they're very much international cases, which, to be honest, could just as easily have been in international arbitration. So turning to international arbitration, the ICC rules do direct tribunals to think about ADR and mediation. That's Appendix 4, Case Management Techniques, Section 8. However, none of the other main institutional rules that I see in the UK direct tribunals to adopt mediation. I did a little audit last night in preparation for this talk. No mention in the LCIA, no mention in the SCC, no mention in ARSA, no mention in VAG, and indeed no mention in DIAC either. Now, all of these institutions have their own separate mediation or conciliation rules. But in my experience, that just doesn't help, because once you're in an arbitration, you're not going to switch to a separate set of rules. You've got your process, and the tribunal are setting directions, and you're going through to an evidential hearing in the end. What I think is a great pity is that tribunals don't say to parties, look, we should build in 3 months for a mediation at some appropriate time. And that's precisely what I see in the High Court in every case. And in my experience, 80 to 90% of cases settle successfully at that stage. And I really think, there's a reluctance by institutions and a reluctance by individual arbitrators to do this. I had a procedural hearing in an arbitration a couple of months ago, and I was saying to the arbitrator, well, let's just build in a stay for mediation. And my opponent said, well, we don't need to do that. If the parties want to have a discussion, the lawyers can facilitate that. We're both sophisticated firms and sophisticated parties. And that's quite right. And we can, and we may, but my very firm experience is, unless the parties get a nudge, they won't do it, because nobody wants to be the first person to open the door. People always perceive that as a sign of weakness. And I really think parties need a bit of direction. And I think lots of the criticism of international arbitration and its duration and its costs might be mitigated if institutions and tribunals worked mediation into the arbitration process. So that is my own personal perspective on mediation in international arbitration.
Thanks, Ned. It's actually very interesting to know about how to build mediation in a procedural timetable. But I do agree that unless they get a nudge, they may not want to take the first step. Also, I completely agree that it might be seen as a sign of weakness. The other thing I find very interesting is when you say that the costs of the litigation were not given because the party refused to mediate. I think it's a very drastic decision, and it really like should scare everyone, and parties should take mediation very seriously. Now, coming to Alex, since you practice in Qatar, I would just want to explore more with you that in Qatar, there is a real push by the government towards mediation. Qatar is one of the first signatories of Singapore Mediation Convention, as well as they came up with a new mediation law last year. So it'll be very helpful if you can speak about those developments in Qatar.
Yes, thank you. And like Ned said, I'm honoured to be given the opportunity to join a distinguished panel. And Ned, I agree with a lot of all of what you say. In my experience, once you've hit the arbitration button, there's no going back, and you either settle it through horse trading or otherwise, or you reach the conclusion of the proceedings. And there does seem to be scope to build in a mediation process at the beginning of the timetable, almost by default. And I think that's a really, really sensible suggestion. Umar, like you mentioned, I come to this, although I'm English qualified, I have practiced and been based in Qatar for the last 8 years. And so I come to this mediation discussion very much from a Qatari perspective. As you mentioned, Qatar has been one of the first, I think it was the third state to ratify the Singapore Convention. And in doing so, I think it's really shown that the state of Qatar and the Ministry of Justice, for which they should be commended, has taken the bull by the horns and shown that it's a real priority for the state. The Singapore Convention is fantastic piece of legislation, I guess. It allows cross-border enforcement of binding mediation agreements, as provided they are international, and that's something that I think a lot of people don't appreciate, that parties to the mediation agreement, as in the settlement agreement, need to have been in two different countries to be able to take advantage of the Singapore Convention. The other exciting element of the Singapore Convention is that it prevents local courts from accepting jurisdiction in cases where a settlement agreement has arisen from a mediation, and there are countries, and I think historically Qatar has been one of them, where the courts have, in certain circumstances, accepted jurisdiction where there is either an arbitration agreement or a mediation agreement, and have decided that those preconditions are not necessarily mandatory in every case. So I think that really reinforces that mandatory precondition there. I mean, moving on to the other demonstration of Qatar's dedication towards mediation and ADR, and the refresh of its legal laws generally, is the mediation law, which were entered into force at the end of last year, October 2021. And this is a really inspired piece of legislation. It allows mediation settlement agreements to be directly enforceable by the courts, as if they had the status of a writ of law, or a writ of the court. So it's upon signing the settlement agreement after the mediation, and as provided the mediator has signed it as well, you can deposit it with the court within 7 days, and the court will ratify it if it's happy with the procedural formalities that have been satisfied. And you can then take that directly to enforcement, which prevents the old problem of, and perhaps it was an excuse not to mediate, well, it's not directly enforceable, we'll have to go through the courts again to effectively enforce a contractual bargain, when maybe we were trying to mediate a contractual dispute in the first place. So, we will end up having to do the same process. That cuts that problem out entirely. And there are lots of aspects of this legislation, but the other one I want to pick up on is the enforcement of confidentiality in mediation. And this is very, very clear and expressed in the legislation. Not only does it say that mediations are are confidential, but it enforces that obligation with statutory fines for any breach of confidentiality of a mediation. And these can be quite substantial sums. I mean, we're talking up to 5% of the amount in dispute if there's any breach by any party of confidentiality, which I think gives real teeth. And it's effectively a statutory recognition of the accepted terms as we as international practitioners would expect a mediation to be subject to. So I think commend the state of Qatar for entering these two pieces of legislation.
Thanks, Alex. Yeah, I do agree that, as you mentioned, that what the new law has done is that it gives the mediation agreement a sort of sanction by the court, and has to be taken very seriously. A lot of times we come across, as you say, in practice, is that yes, there is a settlement agreement, but the parties still go and file a case on merits as if there is no settlement agreement. Now, I think under the new law, you cannot do that. There are sanctions for that. So it will remain to be seen how seriously it's followed by the parties, but it's a very, very good step to encouraging mediation in Qatar. Now, building on that, so I'll start with Rohit now, is that since the COVID, everything has shifted to virtual, and whatever we were used to earlier when it comes to either formal hearings or mediation is that now people are doing it remotely. So, but talking about the form of mediation, now things are opening up. And I will come to Ned and Alex also on that shortly, is how do you view it? Do you think, what is your preferred form of mediation? What do you find it useful? Do you think that in a mediation, because the end goal is to come to a settlement, do you think it's important for the parties to be there together in a room, because human emotions also play a part in it? So what the form of mediation, so Rohit, what are your views on it?
Thank you, Umang, for making me part of this webinar. It's my pleasure to be here. On mediation, I'll talk from a construction perspective and from a perspective of a stakeholder of construction industry in the Middle East. So your question is, whether virtual or physical mediation. My experience and my view is, if mediation has to be there, I would suggest and I would prefer a physical mediation rather than a virtual mediation. You see, mediation as a fundamental concept is trying to convince both the parties to come to some common ground, which may not be 100% to the satisfaction of each of the parties. So trying to come to a common goal and achieve a closure of an issue or a dispute. Now, as part of that, definitely the mediator will have to do some strong, convincing. He may have to speak to the parties, may have to tell them what are the shortcomings, strengths, and weaknesses of their cases. And in such a scenario, a virtual mediation probably may not be, that kind of, will not be probably most appropriate form of mediation. A physical mediation where parties are all sitting together along with the mediator and submissions are done, explanations are done, parties' positions are understood. Physically, the body languages are understood, the emotions are understood. And based on that, the mediator decides that how amicably the issue could be resolved. I'll share one of my experience. It was in an international ICC arbitration where, as Ned said, that unless you are nudged. So in this scenario, I saw that the arbitrator called the parties to the breakout room and told them that, look, guys, both the parties have some strength and some weakness. So it's not that one party wins, another party lose. So it's better that you guys should probably explore a possibility to sit down and mediate. And within that venue of the hearing, a separate room was arranged, both the parties, and it was a construction project within Middle East. The dispute was under the Middle Eastern laws. So both the parties had separately arranged a venue and sat together without the presence of the arbitrator, but knowing the fact that, in front of the arbitration tribunal, what was their position, how strong, how bad. Experts had given their opinion. They knew how much is the quantum of losses, which they thought were high, have now been reduced by the experts. So all those things were there. And then when both the parties sat physically, face to face, initially there was a lot of heated discussions, debates, but finally the parties were able to come to a common ground. So in my view, physical mediation is better than virtual mediation. Saying so, I still am a great fan of virtual arbitration, but probably from a mediation perspective, I would prefer, my preference would be physical.
Okay. Ned, I'll come to you now. What do you think about the form? How important it is to have, as Rohit saying, physical mediation?
Yeah, but it's amazing, isn't it? I mean, what the change over 25 months. And 2 years ago, it would seem to take half of my firm's IT team half a day to organise one video call. And now everybody's just jumping on video at a second's notice. So I had never done anything approaching a virtual mediation before COVID. Since COVID, I have done several fully virtual mediations with multiple parties from multiple jurisdictions, all on camera. I have been in different physical places for my clients who've been international, and the mediator has been on camera too. And really, to my surprise, it's worked. I really didn't think it would, just because, like Rohit said, I thought it was so important to get that personal connection and get a deal. But they were all pretty tricky disputes for legal and personal and business reasons, and they all settled. I've also did a hybrid mediation, which was kind of interesting. So it was the summer of 2020. We were kind of in, I guess, partial lockdown in London. So there were rules on how many people could meet indoors. So he said we can have 3 people on each side and the mediator in a socially distanced room in August 2020. And it was me, 2 of my clients on the other side, one solicitor, one barrister, and one client. And the other people on both sides had attended by video screen. And that also worked quite well. I have to say the people on video screen were kind of watching the plenary session, I guess, but as far as I was concerned, they just dropped away. And I from my perspective, I had my 2 key decision makers in the room with me. So it really has worked much better than I would have expected, kind of in the same way that actually virtual hearings, both in court and arbitration, have worked better than I expected. However, I basically agree with Rohit, and I'm looking at some mediations coming up, and it's expensive to fly people to London, Paris, or Singapore. But I still am thinking, ultimately, you want to give a mediation every chance of succeeding. And I still think you probably have the best chance if the key people are together in the same place physically.
I think that chimes with my experience, Ned. I think that they're different beasts, and there's not necessarily any point or any virtue in differentiating them just as the same entity. They are different processes, really, as far as I see them. And they have different advantages and disadvantages, and you hit absolutely on cost. And especially in a multi-jurisdictional mediation, the cost saving can be fantastic. However, I think that the drawbacks of an online mediation are probably the same as an online cross-examination. You don't get to look someone in the eye. You don't, and often a mediation is the first time, especially in a contentious construction setting, where the parties have looked each other in the eye for quite a long time. And to be able to get in the same room, put your points forward in the plenary, and be able to read reaction is an invaluable first step in a mediation. However, I think the advantages of an online mediation are that it's less draining. It can go on for longer because you're not kind of sat exhausting the biscuits in that breakout room, just waiting for the mediator to kind of finish shuttling with the other side before he can come and see you. You're just getting popped up into your screen as you're mid chatter about the F1 or whatever it is, or of course your case. And there's much less just not hanging around, but sitting with each other, having an opportunity to discuss the merits, the different factors involved. It tends to be more kind of business-like, I think, on an online mediation. You talk about the particular issue or particular fact or issue that the mediator mentioned, and then it's kind of cameras off until your next pops up. So perhaps it's a bit more disjointed, but I think they're great for and appropriate for certain circumstances.
Thanks everyone. Yes, the pandemic has really changed a lot of things, broken a lot of stereotypes which people had. And I think my view is that the parties are sensible commercial parties, and if they want to settle, they will, at the end of the day, have something in their mind on which they can agree on. And the process only adds too much to it, but at the end of the day, come down to the parties. And yes, expense is a very big factor. Now, coming on the next topic, Ned, since you are very experienced, you have done so many mediations, is what is the approach a party should look from a mediator? Is it preferable to have like a very formal mediation, like a mini hearing or mini arbitration, or is it preferable to have, as you say, a relaxed approach, not like an arbitration or a litigation, but more like just having negotiation and discussions with the parties? So on this, first I will start with Ned, and then Alex and Rohit, they can also add in their experience and views on this.
Thank you. So, I mean, these are just my personal views of what I think have worked. I generally tend to instruct mediators who are professional mediators now. So they might have been, QCs or law firm partners for 20 or 30 years before they became mediators, but now all they do is mediate. And what I typically like, to be honest, is a combination of the two approaches you mentioned around. I like to have, I think it's important for the parties to really ventilate their legal arguments. I want the opportunity to put my client's case as strongly as I can, and I want the other side to listen to it. And to be honest, I want my client to listen to the other side's case too, because clients can get quite entrenched in their own view of a case. And I also think it's important for my own clients' confidence to be kind of shaken up and them to get the feeling this is what it's going to be like if we go to an evidential hearing or we go to court. Somebody's going to be sitting in judgment. Having said that, you go through that process, but you're then there to cut a deal. And I think sooner or later, you need to cut a deal, and then it becomes very commercial. And I need a mediator who is going to be comfortable with that and is going to step away from the law.
Okay.
I'm sorry, just one final point. I do think it's important, from my perspective, a mediator remains pretty neutral.
Yeah.
And there's some mediators out there who will give you a view on the merits. And I personally am not comfortable instructing somebody like that. It might be great if they agree with you, but if they don't agree with you, you're just not going to settle. I really think that is an unhelpful dynamic. And I know there's some people who have a reputation for that, and people tend to stay away from them.
Yeah, sometimes
mirror that, Ned. Sorry,
I'm just saying, seconding on Ned, sometimes people can't resist the temptation. Alex, sorry.
Well, I was going to just build on that. And for me, it doesn't necessarily matter about the formality of the proceedings, and that can be adjusted as appropriate for the case. What I think is the most important thing in any mediation, and even more important than necessarily the preparation that you put into the mediation, which I would rank as second most important, is the selection of the individual mediator. And the personality involved and their background makes so much difference to the chances of settling, that it can't be underestimated. And in many ways, it doesn't matter what the right person costs, as long as you get the right person, because they will be critical to either bashing heads together if that's what they need, or identifying interests, exploring solutions, going for the win-win if that's appropriate. And Ned, I know you said you don't like someone who gives an opinion, but sometimes I find it's helpful. If there are two parties that are being intransigent on, for example, say a valuation issue on a construction matter, it's not often you do need a kind of a dose of realism injected into the discussion, and a kind of evaluative mediator can give that, where, and then the parties are kind of forced to say, well, gosh, if that independent third party is thinking that my $100 million claim is actually only worth 20 or whatever it is, gosh, maybe a judge could, or a tribunal could be coming to the same conclusion, and I need to start thinking seriously about when I'm going to accept that offer or put an offer on the table. So I'd say I would encourage anyone to put more time into the considering the right person, and not settle for the selection by some kind of forum or the selection by another person of an appropriate mediator. It's got to be done by the parties. Right? Does that chime with your experience?
Yeah. So I fully agree what Alex and Ned said. Mediation as as a form of dispute resolution has to be a mix of formal and informal kind of process. Formal probably when parties are presenting their cases and putting themselves in front of the mediator to explain what the cases are, and informal where the mediator has to convince the parties to come to a common ground and a common point. I have been involved in a couple of mediations, not in construction but outside construction, wherein the dispute was primarily more related to the emotions and egos of the parties. So therefore, in such a scenario, the mediator could understand that it was not anything to do with the law or anything to do with the facts. It was more that one party thought that my case is strong, and I have been, the scenario was that because the other party has made a lot of money, therefore I should be compensated or I should be given something extra, even though he may not be fully entitled for. So in such a scenario, a kind of an informal discussion and informal convincing by the mediator is definitely essential. So it has to be a mix of formal and informal. But what Alex said is absolutely right. The personality of the mediator has to be taken into consideration. It has to be a convincing personality, strong personality, along with the fact that he understands that what are the actual pain points of the parties. Then only a mediation can be successful.
Well, I'm interested in all of your opinions as to whether personality or technical experience is the most dominant factor in the selection of a mediator. Because a lot of people go by technical background or technical experience.
Yeah, so in my view, probably that may not be the right thing. Only technical experience means you have a person who is so stubborn and is not convincing, is not able to understand, where the parties are coming from. A mediator as a selection should be such that he or she should understand, how to bring the parties closer to each other. A technical person who is strictly going by what is the, what are the cases of the parties probably might not be the best person in my view.
Thank you. Yeah, this is something we wanted to touch upon regarding the selection of a mediator. It's a very, very important topic. And I think personally it helps if parties jointly nominate a mediator, because I think there is a trust which has built up that they can repose on the mediator. Now, as Ned earlier said that he instructs people who have been doing this as a profession for a long time, and either they are QCs or law firm partners. So what are your thoughts, as Rohit said, that you don't want to instruct only a technical person as a mediator, but who should be an ideal mediator further to what you think about it? What qualifications one should look for while appointing a mediator? Ned.
I mean, so doing commercial disputes, I'm really pretty, deal with a wide range of sectors. So for me, a particular sector expertise isn't vital, and most mediators, just like me, will have done disputes across a whole range of sectors. So I'm not particularly fussed about that. I am very conscious that mediators pick up a whole case on, they have half a day to read the position papers, and then they're into discussions and into a mediation. So they need to deal with a lot of law and a lot of detail very rapidly. So, you want somebody who is smart and on top of their game. And I'm always massively impressed that mediators can pick up so much material so quickly and argue the toss with both sides. So I think that's vital. But beyond that, I think, just like Alex said, it's really the personality of the person, and it's nudging the parties together in a way that they feel like they are not being pushed, because that will just cause people to resile. But nevertheless, driving them rather than just letting them state their positions and walk away.
Okay.
Yes, and we haven't actually mentioned that ex-judges, I find, are excellent mediators. they're used to taking on the great amount of detail, as Ned mentioned, and seeing both sides of it, but but resisting the temptation to offer solutions. So I found them to be particularly successful mediators.
Assuming they resist the temptation to offer their judgment, which I can think of a couple of times they haven't resisted that.
But otherwise, it would depend on the personality of the parties, and that's such a lawyer answer to give. But it really does depend, I think. If you've got, if you've got strong kind of typical construction parties that are both quite bullish about their position, you need someone who's just going to smash some heads and inject some realism. Whereas if you maybe on a more commercial matter where there are relationships, where there are more sensitivities involved, then someone who's more softly can be useful. And we haven't touched on how many mediators. And actually, I've never done a mediation where we've had more than one mediator involved. I've had kind of a technical assistant, but never more than one mediator. And I'm interested, is there any experience on that kind of, or even a dual, like one mediator appointed by either party, as you often see with the kind of family type media or family conciliations and mediations?
I think in India, there was a very big case. It was a case which was ongoing for probably 30, 40 years in various courts of India. And, it was a huge case, probably Umang might be knowing it. And there, the Supreme Court of India appointed 3 mediators to find a solution to that problem. It was a massive case affecting probably millions and millions of people. But ultimately, of course, the mediation was not successful. But that was one instance where I saw that on the instructions of the Supreme Court of India, 3 mediators were appointed, one by, I think all 3 were appointed by the Supreme Court, not like a typical arbitration where you have one from one party and then both appoint the chair. It was unlike that, but it was a group of 3 mediators, which that's the only experience. Personal experience I don't have, but that's what I read in the news items.
So I've done a couple of mediations where the mediator has had a kind of pupil mediator with them who has actually been a pretty senior lawyer, and I thought that's just added resource for free, really. So I've liked that. I've had one mediation where there were 2 mediators, and it was just a really big multi-party dispute. And to be honest, part of the reasoning was just there's so many people sitting around rooms. I think this was a 2-day one. That unless we have 2 people kind of talking to people every 6 hours, they're just going to walk out. And actually, I think that did work, and they did kind of act in concert. They were from the same set of chambers, so that they knew each other well. So I think that did work for a big multi-party mediation.
Thank you.
I was just thinking, just while we're on the subject of selecting mediators, one other kind of interesting, important topic is diversity in mediators. And just like you said, Alex, you kind of want the best shot of, it's so important to choose the right mediator, but I do think that means you're very conservative, because you just want somebody who you've worked with before. And I know personally, the people I tend to instruct, you couldn't have a more old, white, male set of pool of people. And that is a problem. It's not helpful for very diverse international parties. So I think the profession as a whole needs to think about diversity in mediation, which I think is actually even worse than arbitration or judiciary.
Yeah, I think this is important, and especially I think it's confined to a few person doing it. And when Alex, when you were talking about panel of 3 mediators, so it's not my experience, but I know of it because before I came to Qatar, I was working with Shardul Amarchand in India. And in Amarchand, when the split happened, so it was supposed to be one firm split into 2 firms. So there was a huge legal dispute at that point of time. And I think the court appointed 3 mediators so the managing partners can discuss and sort the dispute out. So that's the only experience or incident I have heard of that a big mediation happening for the firm I was working for earlier. Now, my next question is, is directed to Rohit first, is that talking about construction industry, we don't see a lot of disputes settling through mediation. I know there are different kind of dispute resolution mechanism. FIDIC provides for DAB, then sometimes we see expert determination. But mediation is something which we don't normally see in the construction contracts. Yeah, it is there in some of the contracts. So why is that so? Why don't we see a lot of mediation being used as a tool in construction industry?
Yeah, Umang, my experience of mediation in Middle East in the construction industry is not very, great. I have hardly seen any matter getting resolved through mediation prior to entering into arbitration related to the construction industry. What I see, the reason is, and as you said, that typical construction contracts have got a lot of steps prior to entering into arbitration, DAB, conciliation, sometimes mediation, amicable settlement, engineer determination, and all that. But what I see is, probably the prime reason why mediation is not very successful in Middle East and in construction industry is the lack of trust between the parties. What is happening is a typical construction contract is 3-4 years, 2-3 years kind of a contract, big money, big issues are involved. And both the claimant and the respondent, or both the parties, have gone through so much that there is a lot of mistrust between the parties, which has spanned over probably 2 to 3 years of time. And also issues are complex. Typical issues are delay issues, who has caused the delay, and then probably because of that, how much is the extra claim and prolongation cost which is going to be paid, technical changes and all. So these are some very distinct kind of issues which you see in a construction dispute. And what I have seen is that even if there is a mediation requirement prior to entering into arbitration, what people are looking at it is just as a tick in the box. They will just think, oh, it's mediation, let's have a mediator appointed, let's just have run through it probably for a week, 10 days, and then close it and go to the arbitration. So they are not taking it that seriously, especially in Middle East. Unlike probably Ned's experience in UK would be quite different, where I see that mediation is useful even in construction projects. But in Middle East, what I've seen is that basic mistrust is there between the parties. And because they have gone through so much for 2 to 3 years of their stay, the project managers of both the sides, the engineers, the people who are involved, and at the management level also, they are basing their opinions on what is the decision of the project directors and managers. So therefore, that mistrust is there, as a result of which mediation I have not seen it to be very successful. And sometimes I've also seen, in case you go to a mediation and you lose, one party doesn't get what it is expecting, then of course the other party probably, sets aside the settlement agreement and goes to the arbitration. So sometimes that mistrust is also there, whether ultimately whatever the settlement has been achieved. Now with the coming of the law, of course, settlement agreements are given more weightage. But prior to that, people were violating the settlement agreement and going to the next phase of dispute resolution. So that's been my experience of the construction industry.
Alex, do you want to add to that?
Well, it reminds me that my colleagues in the UK at Eversheds were putting together a global guide on collaborative contracting and were seeking opinion from the Middle East, which I was consulted. And I had to say, I put some feelers out to some clients, and the answer was universally, we've never heard of it or we've never done it. And that chimes with my experience. There's nothing collaborative about the way that contracts are set up here. They're set up to make a combative environment, and the claims notices, you don't see any C here or any kind of partnering process. And I think that speaks of the mentality, and perhaps the historic mentality, but also the current approach. And if throughout the project you approach it on a combative basis, that things aren't going to change just when you get to the end of the project and the dispute is crystallized. And I think to the extent that mediation is written into a contract in some kind of multi-tiered dispute, that's usually in order to frustrate the arbitration process to delay it in some way. And you've got many months of meetings before you roll into a mediation, before you can then hit the arbitration button. And it is seen as a bit of a formality. So I think there needs to be a bit of a kind of paradigm shift or a mentality shift here in the Middle East before we can reject that kind of lack of trust and between the parties and build in a more partnering approach, which hopefully will be more conducive to mediation.
Thanks, Alex. Yes, I agree with that. Ned, what has been your experience in this on construction industry or technical cases and mediation? Do you think they sit together well?
So I'm really not a construction lawyer, so won't pretend to be. My impression, having worked with lots of construction lawyers in my firms, is that there is mediation. I think adjudication in the UK construction industry does knock out quite a few disputes, which, if they were general commercial disputes, might go to mediation. So most of my experience of mediation has been kind of on one-off big disputes, rather than a long-term relationship.
Okay.
Personally, I kind of agree with Alex that I'm not sure how well mediation works when I've seen it in that context. I have found the kind of discussions between senior management, that process, quite useful in a number of long-term relationships I've dealt with, and that has brought people together. But that's obviously at quite a high and quite a commercial level. Conversely, my experience is that if things have broken down so badly you need a mediation, you probably need a litigation or arbitration process to get the parties really to understand their legal positions before they come together. So I'm not a massive fan of the kind of you have to mediate before you arbitrate or before you litigate. So I personally think that's often too early in the process.
Albeit, Ned, that's an excellent point you make about allowing the parties to ventilate their dispute before they get into an arbitration. And some clients say to me, oh, well, mediation will be a waste of money. Nothing will happen. No, we won't settle. And often my response is, well, you might not settle, but it doesn't necessarily mean it's going to be a waste of money, because a lot of the preparation for the mediation, we will have to do anyway. We will have to know our case. We'll have to prepare position papers, which will get fed into pleadings. So let's do it now in a collaborative environment rather than leave it till later in a combative environment.
I do agree, and I can think of multiple occasions where my clients have said it's too early to talk. It's too early to talk, and then we finally have a mediation, and then they say afterwards, "Well, we should have done that a year ago."
So as I was moving forward, then the next theme which I wanted to discuss, and I have a question from the audience as well, which ties in with the theme, is your experiences of mediation, and particularly if you have any experience of ICC mediation, or how do you rate your experience of the mediation? And so Ned, if you can, we'll start with you.
It's going to be a quick answer, but as I said at the beginning, I've got 0% of my mediations have been in arbitration, so no direct experience of ICC mediation.
Alex?
Yeah, no, mine have all been ad hoc, so I'm afraid not to be much help.
Now we'll come to Rohit.
I'm also in the same boat, so it's all been ad hoc rather than ICC.
So it's like, as a moderator, I have experience of ICC mediation, and it's not a good one. I think it takes a lot of time, it's expensive, and if parties don't agree on a mediator, it's problematic because the ICC pool is very wide and they can appoint anyone as a mediator, and that process might not work very well. That's what happened in my case as well. The mediator was appointed, the parties were not comfortable with it, and after a couple of months, even before reaching to a position statement stage, the parties thought that, listen, this is not going to work out, and they pulled out of the mediation. So my experience of ICC mediation is not very good. Now, before we finish, just the last theme is that, which is a proverbial question, is that mediation as a pre-dispute resolution step, whether do you think it complements arbitration or litigation? So I'll start with Ned. As a pre-dispute step in a contract in a mediation, what do you feel about it?
Yeah, I mean, as I just said, I tend to think it is too early, and I haven't seen it on a lot of occasions. The vast majority of mediations I have done have been part of a court process. Having said that, just like Alex was saying, I think it's too early. Maybe just get the parties in a room and see whether you can either resolve things or at least narrow things. And I certainly think with more sophisticated parties, it can work. Most of the pre-dispute or pre-process mediations I have done have been against insurers. And, an insurer litigates day in, day out, so they know what's coming. And that they have worked quite well. So I definitely think there's a role for it, with the caveat that I do think parties really need to prepare their case properly, whether it's for the purposes of mediation or in a court process.
Yeah.
And not wanting to repeat, I think that there is a complementary, or they are complementary. And it shouldn't be underestimated the advantage one can get from being able to look the other parties in the eye and put your case forward to them in a way that you cannot in an arbitration until very late in the process. I think the other advantage to doing them in a kind of arbitration setting is that it gives one, if there have been offers exchanged, which there usually are in a mediation, it gives you at least an idea of the starting point. Whether you think, even if you can't mention it in the arbitration, obviously, but at least later on, if they're claiming 200 million, but they're offering 100 in the mediation, they probably don't have that much trust in their own claim, and it helps inform your own offers within the arbitration process itself. So I think that it's useful in that regard.
Yeah, so in my view, what Alex and Ned said is absolutely right. I'm also, supportive of mediation as a form of resolution of disputes, and especially, in construction sector, what you see today is cash is the king. So the contractors primarily are getting affected because of the lack of the cash flow, sufficient amount of money, being put into the project. So in case mediation as a format is accepted and agreed by the parties, this will infuse cash into the industry, into the projects, and as a result of which, further damages which may happen because of probable lack of money, lack of cash availability might be reduced, and hence on an overall perspective, parties will be definitely better off in case they are able to mediate and come to a common settlement and common ground.
Thank you, everyone. I have one more question from the audience, which I'll just put forward to it, is that for commercial lawyers who are doing drafting, how do you suggest that, how should they encourage clients to agree on a mediation? Should there be an ad hoc mediation clause, or would you want to have nudge them towards an institutional mediation, saying that it's more organized? So Ned, what's your advice on that?
Yeah, good question. I think the LCAA, the ICC, the institutions have mediation clauses, so I wouldn't reinvent the wheel. I would use some of that wording if you want a specific mediation clause. To be honest, I'm just thinking out loud here, but going back to what I said at the beginning about encouraging tribunals to adopt ADR and mediation, I'd say build in your arbitration clause, but then actually build in a separate clause, a sub-clause which says, and the tribunal shall encourage the parties to use ADR, including mediation. Why not put it in and drive people into mediation?
And put specific cost consequences available to the tribunal if parties don't approach mediation in the right way. And this, I agree with this is a fantastic question, and it's one that I wish more of my clients that end up in arbitration had considered their dispute resolution clause at the beginning of the outset of their contract. mediation is a consensual process by its nature. And I don't think it works well in a situation where one is compelled to do it, because you approach it as a tick box, or it's often tempting to do that rather than in the spirit that it really needs in order to achieve a proper settlement. So I would encourage a non-mandatory process in the contract, but one with cost consequences. That if there's not a good reason, or if there's a good reason not to mediate, then fine. But let's show that the parties have at least considered it properly.
I fully agree what Ned and Alex said. In my view, at times my experience has been that if it is an ad hoc mediation, probably, there is also an issue on the selection of the mediators. So in case it's an institutional mediation, probably that issue might be resolved. So of course, I do not have the experience of an institutional mediation, but at least that portion of, disagreement between the parties on the selection of mediator itself will be resolved.
Thank you, everyone. Now we are almost approaching end of our time. So once again, before I conclude the session, I'd like to thank everyone for joining, for the insightful questions our audience have asked, and to Ned, Alex, and Rohit for taking time out from your busy schedule and giving us insight into your experiences and your thoughts. Especially, I found Ned's, I'll say, Arbmed technique which he wants in the arbitration to be built I think it divides opinion across, but there's something if implemented correctly, can really resolve the disputes, especially in long drawn 2 or 3 year arbitration process. So once again, thank you everyone, and I'll just conclude the session.